Good morning, good afternoon, good evening, and welcome to the October installment of the Michigan PIP Monthly. My name is Justin Grimsky, and I am a partner in the Seacrest Wardle Troy office and a proud member of the firm's motor vehicle litigation group. As a reminder, my contact information will appear on the last slide. So if there is anything you want to discuss, please email or call at any time. So what are we going to be discussing today? Well, first, we're going to discuss the recent Spectrum case and what is relevant in evaluating the reasonableness of charges in no-fault provider lawsuits. Then we're going to discuss a change in priority defenses as outlined in the recent Griffin case. We're then going to discuss what constitutes proper notice of a claim as outlined in southeastern Michigan. And then finally, as a bonus, a breakdown of a recent case that reminds us always to look at comparative fault in third-party negligence cases. So let's begin. I wanted to start this month's installment by visiting the recent Spectrum Health case in more detail. Amber Holloway briefly touched on this case in last month's podcast. If you're not aware of this case, it's very important, especially for defending no-fault provider suits. So what happened? Patient was injured in a motor vehicle accident and followed up treatment with the provider. The $225,000 bill was submitted to the insurance company, who paid 80%, leaving roughly $45,000 unpaid. In doing so, the insurance company stated that anything above 80% was unreasonable. The provider disagreed, filed suit for both the remaining balance and an award for interest and attorney's fees. During discovery, the insurance company sent interrogatories to the provider seeking information to support its argument that anything above that 80% was unreasonable. The attorney sought a laundry list of items, including the Medicare rate for these charges, the rates health insurers, including Priority Health, Blue Cross Blue Shield, have paid for similar treatment, and whether charges for uninsured persons or cash payments were the same as for individuals with no-fault insurance. In response to those interrogatories, what did the provider do? Well, they objected. Irrelevant, not reasonably calculated to lead to discovery of admissible evidence. So, the insurance company filed a motion asking the court to rule on a number of issues, one being what constituted relevant and admissible evidence regarding the reasonableness of the provider's charges. Well, the trial court denied the motion, thereby failing to admit into evidence the items sought by defendant. The insurance company appealed, and again, the relevant issue on appeal concerned the identification of factors that may be considered when determining whether a provider's charge was reasonable under the No-Fault Act. The brief filed by the insurance company primarily focused on payments providers accepted for like services from others, such as Medicaid. Now, in its lengthy opinion, the court held that the determination of reasonableness is more broadly concerned with measuring whether a charge is fair and not excessive. Thus, as the court noted, the amount that others pay for the same good or services is a pertinent factor to be considered when determining reasonableness. The court also noted that there's nothing in the plain language of 3107 or 3157 that precludes consideration of third-party payments when determining a no-fault insurer's liability for reasonable charges. The court then reversed the trial court and remanded. Now, from a practical sense, this case is very important as it defines that what others pay, including health insurers, Medicaid, Medicare, uninsured patients, is pertinent in a reasonableness discussion. Now, notably, the Court of Appeals in the Spectrum case held that these items may, and I emphasize may as it was italicized in the case itself, may be admissible. Thus, it's strongly advised that at a minimum, discovery is artfully crafted such that a similar laundry list of items is sought in each provider case where reasonableness is at issue. Now, this may even include an analysis of what a third-party payer is paying for a particular CPT code and what that provider has accepted as satisfactory payment. This now likely discoverable information, coupled with a proper expert similar to the one used in the Spectrum case by the insurance company, will provide a great framework for your defense regarding reasonableness. If plaintiff objects, be aggressive in pursuit of that information, whether it's via motion or otherwise. Moving on, slide 5 details a very important case that deals with identifying higher priority insurers. This published decision was handled by Seacrest Wardle at the trial and appellate court levels. Now, in Griffin, plaintiff, a motorcyclist, was injured in May of 2016 when a truck merged into his lane and he crashed while attempting to avoid the truck. 5 days after the accident, plaintiff retained an attorney who sent a letter to the truck driver. The truck driver's name, address, and phone number were in the police report. The letter informed the truck driver of plaintiff's intent to pursue legal action. Little was done by plaintiff over the next 11 months. In April of 2017, plaintiff filed suit against Trumbull, who was plaintiff's personal carrier, and the Michigan Assigned Claims Plan. Also in April of 2017, plaintiff hired a personal investigator to try and identify the truck driver's insurance company. That personal investigator was unsuccessful at that time. However, 5 months later, in September of 2017, Trumbull subpoenaed the truck driver for deposition. The truck driver appeared, and based on his testimony, another insurance company was determined to be higher in priority. Based on that, Trumbull and the Michigan Assigned Claims Plan filed motions for summary disposition pursuant to MCL 500-31145. Plaintiff heavily objected to that motion for summary disposition as the new insurance company that was higher in priority was not determined until well past 1 year of plaintiff's injury. Regardless of plaintiff's objection, the trial court granted the motion for summary disposition. The court found that this new insurance company could have been identified within 1 year of the accident if the plaintiff had acted with reasonable diligence. The court also granted motion for summary disposition for the Michigan Assigned Claims Plan. Plaintiff then appealed. In an opinion that took nearly 8 months to be issued, the majority affirmed the trial court's granting of summary disposition, but for different reasons. Instead of a reasonable diligence standard, the court held that the appropriate question is only whether a higher priority insurer is identifiable, without regard to diligence or time. The court noted that plaintiff had a duty to identify the highest priority insurer. The truck driver's identification was listed on the police report. Plaintiff could have subpoenaed him for deposition, just like the defendant did, especially since plaintiff had retained an attorney 5 days after the loss. As such, plaintiff did not take the proper steps to identify the highest priority insurer. So by waiting until the final hour to file suit, plaintiff took the risk that the higher priority insurer would not be identified until potentially 1 year after the statute had expired. Now, the dissent in Griffin opined that a reasonable diligence standard should still be adopted, and if the highest priority insurer is not identifiable with reasonable diligence, then the next priority insurer would be liable. Now, this significant issue may well garner the attention of the Michigan Supreme Court should the plaintiff seek relief there. But as it presently stands, the appropriate question is only whether a higher priority insurer is identifiable. There is not a reasonable diligence standard. Next, I wanted to briefly touch on the Southeast Michigan Surgical Hospital case. The Court of Appeals in that case was presented with the issue of what constituted proper notice to an insurer. As a reminder, this took place prior to the June 2020 no-fault amendment when providers did not have a direct cause of action. Now, specifically, the issue in Southeast Michigan was whether a healthcare provider sending a bill without more amounted to written notification of a claim under 531.12. The Court of Appeals held that a bill without an assignment is not proper notice of a claim. So what happened in this case? In July of 2017, patient Toma sued defendant insurance company. 1 month after filing suit, Toma received medical services from plaintiff Southeast Michigan Surgical Hospital. On that same date, he assigned his rights to Southeast Michigan Surgical Hospital to collect no-fault benefits for those services. In August of 2017, defendant received Southeast Michigan Surgical Hospital's bill for those services. Subsequently, in May of 18, patient Toma and defendant reached a settlement wherein Toma released defendant from any PIP claims incurred from the date of the accident through April 10, 2018. However, on July 2, 2018, Southeast Michigan Surgical Hospital sued defendant requesting payment for services that they provided to Toma in August of 17. Defendant moved for summary disposition and argued that Southeast Michigan Surgical Hospital's claim was barred by defendant's settlement agreement with Toma. The district court denied defendant's motion. On appeal, the Court of Appeals reversed. In reversing, the court noted that because healthcare providers only have a right to payment of PIP benefits from a no-fault insurer if they have an assignment of rights from the insured, a medical bill without an accompanying notice of an assignment of rights is not notice of a claim under 531.12. In applying that rationale to the case at hand, the Court of Appeals noted that the bill sent to the insurance company merely put them on notice that the provider had provided medical services to the patient. It did not go as far to put the defendant on notice that the provider had a claim to PIP benefits. As a reminder, this is an important decision to keep in the back of your mind for cases that involve motor vehicle accidents and/or the date of service prior to June 2020. Moving to the last slide, I know this podcast is entitled Michigan PIP Monthly, but if you promise not to tattletale, we're going to finish with a reminder regarding third-party negligent cases. Now, this case, Estate of Homrick, was a pedestrian versus motor vehicle accident that resulted in the trial court granting defendant's motion for summary disposition based on plaintiff being more than 50% at fault and also a sudden emergency existing. So what happened in this case? On the date of loss, 5:30 in the morning, prior to sunrise, 4'8" plaintiff attempted to cross the road in between two recycle bins. As defendant drove down the unlit roadway, he struck plaintiff. After defendant struck plaintiff, another vehicle driving behind defendant also struck plaintiff who was lying in the roadway. Both defendants filed motions for summary disposition in the trial court, which were granted pursuant to a comparative fault analysis. The estate appealed. The court reminded us, in order for a plaintiff to recover, he or she cannot be more than 50% at fault pursuant to 531.35(2)(b). The court also analyzed the sudden emergency doctrine and noted that for a sudden emergency to apply, it is essential that the potential peril had not been in clear view for any significant length of time and was totally unexpected. In affirming that, there was no question of material fact that plaintiff was more than 50% at fault. The court noted that, while the road was unlit, recycle bins lined the roadway, there was no evidence of any cell phone, radio distraction, and plaintiff was wearing dark clothing when she darted into the roadway without expectation. The court discounted plaintiff's expert, who opined that plaintiff was visible for 2.2 seconds and should have been visible to the defendant. Now, in a paragraph on page 3 of the opinion, I urge you to read, the court noted, summary disposition is not precluded simply because a party produced an expert supporting its position. A party opposing a motion for summary disposition must produce more than mere conjecture and speculation. Now, also in affirming that the defendant was confronted with a sudden emergency pursuant to 257-627-1, the court applied the above facts and specifically identified that plaintiff was not in a clear view for any significant length of time, and her darting into the roadway was totally unexpected. This case is to serve as yet another reminder that liability defenses are oftentimes successful, and liability should be looked into just as much as an alleged McCormick injury. Now, towards the end of this estate of Homrich opinion, this case also gives a great analysis as to a witness's recorded statement provided to an insurance representative and why that is not discoverable as work product. I urge you to also give that paragraph a brief read. And here we are, the end of the October Michigan PIP Monthly podcast. Thank you all for attending. Now, as noted, my email address and direct dial phone number is listed. So if there is absolutely any questions or comments that you may have on any of the topics presented today or any questions in general, please feel free to reach out.